Thanks for taking the time out of your day to come and join us for this webinar on immigration law. I know that there's been a lot of updates in that area. In fact, in speaking with Elizabeth earlier, I was told it seems like there's updates daily right now. So really excited for her to share a lot of these updates. Before I introduce her, I'll just introduce myself quickly. My name is Dave Kitchen. I'm the VP of Sales at HR Covered. Most of you who attend our webinars regularly are used to seeing Brett. I work closely with Brett. If you're one of our partners, I may have even met you at some of the events that Brett and I attend. So welcome. Thank you for attending. So without further ado, just introducing Elizabeth Long. Elizabeth is a leading immigration lawyer in Canada. She is an active advocate of immigrant and refugee rights in Canada and frequently presents and advises on immigration issues to organizations, universities, members of parliament, unions, and the media. She's also testified several times before the Parliamentary Standing Committee on Citizenship and Immigration on various immigration policies. Elizabeth holds a Juris Doctor law degree from University of Toronto and a Bachelor of Arts degree with honors in psychology from Memorial University in Newfoundland. She also holds a Master's of Law degree from Osgoode Hall Law School, York University, where she focused on the intersection between immigration and labor and employment law for foreign workers. Elizabeth has also been certified by the Law Society of Ontario as a specialist in citizenship and immigration law, a prestigious list which only approximately holds 65 lawyers in Canada. So a little bit longer introduction than mine. Welcome, Elizabeth, and thank you for taking the time to speak to us today.
Well, thank you so much, Dave. It's a pleasure to be here with you all today. And we have a lot to unpack today because immigration law has just gone through so many changes over the last few months. Last year, we did this webinar and I went through, the various different programs that, you can get permanent residence and some work permits. Today, I'm going to focus just on changes, and just on the changes alone, I will have enough, I think, to fill this webinar. So let me just get started and share my slides. Hold on for 1 second here. Now, I do want to sort of let you guys know about the format of what we're going to be doing today. So everything is recorded and we will be sharing the recordings and slides with you afterwards. But if you have any questions, please put them into the Q&A button on the bottom of your screen. And we will be doing our best to answer as many questions as we can at the end of the presentation. All right, so like I said today, I'm not going to go into basics about, how work permits work today. I'm just going to go right into the changes that have been made in the last half a year, 4 months or so, 4 to 6 months or so, okay? So first of all, I'd like to talk about labor market impact assessments, or the LMIAs. Now, what are LMIAs? LMIAs are the default ways to get work permits for most people in Canada. So in essence, there are different kinds of exceptions to the LMIAs, but for the most part, in order for you to hire an international worker to Canada, you have to normally do a labor market impact assessment, LMIA, where you have to show you cannot find a Canadian to do the job. And then after you get the LMIA, we can apply for the work permits for the worker. So what are the changes to the LMIAs? Well, first of all, there was an announcement in the fall of last year that the government is going to refuse to process low-wage LMIAs in areas where unemployment is over 6%. And, unemployment is over 6%, I think, in most large cities in Canada right now. Calgary, BC, Toronto, Montreal, etc. Okay. And what are low-wage LMIAs? Well, they were basically the median wage for all occupations in each province. But then the government made another announcement which increased the threshold for low-wage LMIAs to 20% above that median wage. So now you have basically, I think in Toronto it's around $34 an hour. In Calgary, I think it might be even more. It's around the $30 to $40 an hour wage level in most provinces now. So basically what that means is, for the most part, if you wanted to apply for a LMIA to hire a new worker or to hire to obtain a work permit for your current worker, you're basically looking at having to offer them a salary of at least something that is above that threshold for low wage. Now there are a couple of exceptions. There are a few exceptions, not too many. One is if you are applying to support their permanent residents only and not to get another work permit for them. So there are, and we'll talk about this because the government just before Christmas also said that they were going to cancel this as well. But currently there is a way where if you applied for an LMIA, that could help your current worker obtain 50 points, sometimes 200 points, for what's called arranged employment for permanent residents for express entry. So that's what this is, okay? So if you're only applying to support permanent residents and you're not applying to support work permits, you could still have a wage that is falls under the low wage LMIAs. Now, this is not to say that your salary would be below the median wage for the occupation. The government does have surveys to talk about the median wage for each occupation, and you certainly, to obtain an LMIA, you have to be above that, at or above that median wage for the occupation. We're just talking about the median wage overall for the province, and it's 20% above that median wage in order to get above the threshold for the low wage LMIAs. There are some occupations as well that are exempt: construction, food manufacturing, healthcare, primary agriculture. So I've put some links in here so you can take a look at some of these exceptions to the rule. And I've also put a link in here where you can look at the low wage threshold as well. And to cap that off, the government also, I think this was in November, announced that they will no longer accept financial attestations by CPAs to show that a business has the financial ability to support the salary of the worker. So this becomes a huge issue for many employers if your last year's tax documents does not indicate that your retained earnings or your net profit is higher than the worker's salary. If that is the case, you can no longer use common sense or someone with an ability, like a financial, ability like a CPA, to say, yes, actually the company receives money from, an overseas company, another company outside of Canada, or they have other ways to obtain the earnings. The officers these days are just accepting the tax documents or the attestation from the bank, which is almost never, I've never seen a bank that's willing to issue that kind of attestation. Now, if your worker is currently working for you, then that's okay, because they will accept, if the worker is currently working for you, 6 weeks of payroll stubs to show that you have been paying them for 6 weeks, and that's fine. It's where we have new workers that this becomes more and more of an issue. Also, if you have had an LMIA approved within the last 2 years, you're exempt from having to show these documents as well. Okay, so these are LMIA changes, which really have a huge effect on many employers' ability to even submit and have an LMIA processed. Now, there have been some other changes to other work permits as well. So intra-company transferee work permits. Intra-company transferee work permits are where you are transferring either a specialized knowledge worker or a senior executive management from a related company outside of Canada who has been working there for at least a year to Canada. And there's been 2 significant changes in this category. One is that the salaries for the senior executive managers now need to meet median wage for their occupation. Okay, so before it was only specialized knowledge workers that needed to do this. Now the management also needs to meet the median wage. Secondly, they also now state that in order to qualify for ICT, there has to be 2 revenue generating operations in 2 different countries in order to qualify. What this does is it really limits the ability of a company outside of Canada who only has operations in one country to come and start a company in Canada and transfer the workers to a company in Canada that they have just started and is not generating revenue. Okay, in these cases now we may have to look at alternatives to the ICT, such as entrepreneur work permits, or perhaps we can look at reciprocal employment, etc. But in these cases, so if your company is already in business in Canada, that's great, and you have an overseas company that's already in business, fantastic, you're still okay. But if not, and your company in Canada has not been set up yet, this becomes a problem. Post-grad work permits. These are work permits for international students. When international students graduate, most of them are they are supposed to, if they graduated before from a public university or college, if they graduated from a 2-year program, they get a 3-year work permit. 1-year program, they get a 1-year work permit. That's all changing. So for the current cohort of graduates, that might still be okay because it changed only for those people who applied for their study permits after November 1st of last year. And this is why we're seeing a lot of colleges now announcing that they are closing their doors or they're closing departments, because if the student is graduating from a college or a university where it's a non-degree, not a bachelor's, master's, or PhD, okay? If it is in those situations, in order for them now to qualify for the post-grad work permit, if they applied for the study permit after November of last year, they can only get a work permit if their field of study falls into one of the select few fields of study. Okay, so if not, then they would not be eligible for the open post-grad work permits. And just as a quick note, this is for arranged employment points. If you have someone coming through the IEC class and you applied for a young professionals work permit, they changed the rules so that they will no longer qualify for arranged employment after December 18th of last year. All right, so more bad news. They ended flag polling just before Christmas. They also announced the end of flag polling. What is flag polling? Flag polling is when you have temporary status in Canada, work permit, study permit, a visitor status. And then you go to the US, and when you get to the US, you can often say, look, I don't really want to enter the US. I don't care about entering the US. What I do want to do is go around the flag and come back to the Canadian side so I can apply for my work permit or get my study permit right at the Canadian border. And this has been something that we've been able to use for decades, where basically we can get same-day processing, for example, for a work permit by going to the border and getting it there. Well, since Trump complained so much about, Canadians going, or not Canadians, but flagpoling, and these are one of the things about borders and tariffs and etc., they canceled flagpoling. And so basically what they're defining as flagpoling is going to the States, St. Pierre and Miquelon, nobody goes. That's just little islands just off of Newfoundland, by the way. I'm from Newfoundland, so I know where it is. I don't think most of Canada know where that is, but mainly go to the States, okay? And you're just going there for the purposes of getting your immigration services at the port of entry. And that also includes people who have already had their work permits or study permits approved by the visa post. And then they just need to get their work permits and study permits at the border. They're also not doing that as well. It includes both the land borders and the airports. So, flagpoling is not just someone driving on those. Most people know that, right? You drive to the border, you come back and go around the flagpole. This also includes people who fly to the States for a short period of time, and when they come back, they want to go and apply for their work permits as well, okay? That's also ending as well. So there are a few exceptions to the rule. Americans, citizens, and permanent residents, free trade agreement professionals of certain countries, and spouses as well. International truck drivers who need to go because of their job. And then individuals with pre-existing appointments. I'm going to tell you that right now, most places don't have mechanism in place to arrange the pre-existing appointments. These were mainly done before this announcement. Some ports of entry had the appointments, so if you still had an appointment, you could go there. But I think for most part, that's no longer in place. We'll see if in the future they do this. I think this was a very, very sudden announcement. There wasn't much warning to even officers as well, and so now they're trying to figure out exactly what could be the rules as well moving forward if they make any extra exceptions, for example, these pre-existing appointments. All right, so what do we do now if we don't have flagpoling? How do people apply for their work permits and study permits? Well, if you are inside Canada, you could apply inside Canada to extend the work permit or study permit, okay? And you can only do this now if you have a work permit or study permit. If you don't, you can no longer apply for your first work permit inside Canada. You still have to submit it to the visa post now, okay? You can be inside Canada, but it's just that the office that processes it is no longer inside Canada, it's outside of Canada. But if you have a work permit or study permit, you can apply inside Canada. You cannot leave, though. Please make sure that your workers do not leave while they're on implied status. If they leave, even if they have a visa to come back or they don't need a visa to come back, when they come back, they are no longer able to continue to work. What implied status means is if you applied to submit your work permit extension inside Canada before your work permit expires, and then your work permit expires, but you're still waiting for a decision, you can continue to work in Canada after the first work permit expires until a decision is made, okay? But if you leave during that time, after your first work permit expires and until you get a decision, then when you come back, you're not allowed to work. Now, sometimes if you are getting a worker to change from another job and you had an employer-specific work permit before and you have another employer-specific work permit now, sometimes we're able to get expedited processing in these kind of cases. But normally, these work permits are taking 5 months, 6 months, or longer to process. You could also apply to the visa post. Now, when you apply to a visa post and you say, how do you apply to a visa post? It has to do with the kind of forms and that you're submitting, okay? So if you're applying, both of them are online, everything is online, but you just have to show which way you're applying. So if you're going to submit your application to a visa post, certain visa posts may have faster processing time than the 5 to 6 months. But there's a couple of things. One is you do not get implied status if you apply to a visa post. You only get implied status if you're applying inside Canada. And secondly is if you have an approval by the visa post, and that's great, you don't actually get the work permit in hand. It's never sent to you. It's only sent to you if you apply inside Canada. Instead, the worker is going to need to leave the country and they can no longer just go to the state, drive to the States and come back and pick up their work permit. They're going to have to fly to another country and then they come back and they can activate their work permit. You can travel to the US for other reasons. So the flagpoling is defined as going to the US and coming back for the purposes of, the reason to go to the US was for the purposes of accessing the immigration service at the border. But if you have someone, for example, who is going on a specific business trip or they're visiting a sick relative or etc., and they can show and they can satisfy the officer at the border that they were there for the purposes of, another reason, technically speaking, the officer is allowed to process their work permit. Now, is the officer going to believe them? That remains to be seen. What are the rules for how long someone should be in the States before, the officer can... It used to be that if you, before, under the previous rules, they used to say, well, if you're in the US for over 3 days, then you're not flagpoling. But now I think that's a whole different world. So it remains to be seen as to what the culture would be, what the stated rules might be, what the unstated rules are for officers at the border to accept this. Traveling to another country. So for those workers who are visa exempt, they don't need a visa to come to Canada. If they were to travel to another country and come back to Canada, that's not called flagpoling, and they are eligible to apply for their work permit at the airport. Now, this would only work for visa exempt applicants. For those workers who need visas, they cannot just leave the country, fly back, and apply at the airport. They're not allowed to under the regulation. They have to apply either at a visa post or inside Canada. All right. Let's keep on going. Let's keep this roll going on these restrictions here. We have another restriction that was just announced last week and is in place Tuesday of this week. And these are now they've restricted spousal work permits and dependent children work permits as well. So essentially starting on Tuesday of this week, the family work permits for workers' families are only limited. Before, children were able to get it. Now it's only spouses and only high-skilled workers. Now, even with high-skilled workers, though, there is a difference depending on their occupation. So for those who are in the tier 0 or 1, tier 0 is management, tier 1 is professionals with that usually require university degrees, for example. Their spouse, and only spouses now, okay, can apply for a spousal work permit only if the work permit is at least 16 months when we file the spousal work permit. Otherwise, if it's not 16 months or more, so if they were only getting a 1-year work permit for them, they're not going to be, the spouse is not going to be able to get the spousal work permit. Tier 2 and 3, so these are still high skilled, but they're more of the tier 2 is more the ones where they need college programs, and tier 3 is more of the trades. And these, the same rules as tier 0 and 1, except not all occupations qualify. They have to be on the list of occupations that qualify, and I've put the link here. Now, there are some exceptions to the rule, and it's mainly those people who have already applied for permanent residence through one of the economic programs, not just put their name in the pool. When someone puts their name in a provincial nominee program pool, or someone puts in their name for express entry pool, they haven't yet applied for permanent residence. It's only after they've applied for permanent residence that they can then apply for the spousal work permits. Dependent children can apply for the work permits as well under this, and the work permits only need to be valid for 6 months upon filing of the spousal work permit, or the dependent children work permits as well. Free trade agreements is interesting. When they had announced these restrictions were going to be in place last week, they had announced, I believe it was Wednesday or Tuesday or something like that. They had said, oh, this is what's going to be in place. And they said free trade agreements those covered under free trade agreements are exempt. But in the new instructions, they didn't say anything about free trade agreements. However, free trade agreements are agreements that are negotiated between two countries. So Canada itself cannot unilaterally just refuse to process spousal work permits if they're encompassed in a free trade agreement. But it's not all spouses that are encompassed in a free trade agreement. Some free trade agreements allow for spouses of, for example, intracompany transferees. Some free trade agreements allow for spouses of professionals. But it just really depends on who it is that they're allowing, I think, under the free trade agreement. That being said, maybe they forgot to include free trade agreements in the new instructions, and there's more. But so far, this is what's been in place. Extensions. There's another question about extensions as well. Right now, it says that if you hold a work permit and your spouse's work permit is valid for a longer time than your current work permit, then you can go and extend your work permit, irrespective of what your spouse's situation is. Okay. Now, does this mean that if your spouse is going to apply for a new work permit, that these current rules would apply? Or does it mean that if you currently have a work permit and you're extending it together with your spouse, that the old rules apply? No one really knows for sure. We are trying to get confirmation from IRCC about this. Now, by the way, there's so many changes, as you know, to these rules. What we're going to do is we are going to put you in a news list if you've registered, so that we can tell you about the news, about the new things that are coming up. That will come up for sure. What I tell you today is true today, but who knows, in the next hour or the next day or the next week. Next week, something will change as well. All right. Now, last thing, I promise, for today, for right now. There was one of the, I must say, it did really make him seem like a Grinch. He announced this December 23rd, the minister, that they were going to have a pause on arranged employment points. What are arranged employment points? Well, arranged employment points are points for express entry. And what it is if you have a high-skilled job offer in Canada, that is an offer for at least 1 year after you get permanent residence, okay? So normally, if it takes someone 6 months to get permanent residence through express entry, they'll need a job offer of at least 1.5 years or 2 years. Permanent, of course, is fine, okay? And they must either hold LMIA or a LMIA work permit or an employer-specific LMIA exempt work permit that's where they've worked for the employer for at least 1 year, okay? In those cases, for express entry, they would get either 200 points for executive management positions or 50 points for all of the other high-skilled positions. And so this really gives a boost for those workers who have LMIAs or employer-specific work permits where, you know, it's already been determined that they are going to be of economic benefit to the employer and to Canada. It used to give them a boost. Now, what the announcement is that they, in the spring of this year, that there is going to be a pause on these points. So after they make the announcement in the spring, essentially, all of these workers will no longer have an edge, an advantage to applying for permanent residence. Now, the question I have here is, will they actually do it? Because not that they don't have any intention, I'm sure the minister has every intention to do this. My question is he still going to be in office at that time? Because as we all know, the election is coming in March. So that's what I end up with on this. Now, I just wanted to quickly, go over some strategies of what I would recommend that you do when you're thinking about hiring and retaining international workers. And this is what I talk about with our clients. First of all, we want to try to avoid the LMIA as much as possible. There are many, many different kinds of options that are LMIA exempt. We want to take a look at that and see if there are easier ways to bring people over. We want to have contingency plans. We want to make sure that we have a plan A. If that doesn't work, plan B, plan C. We want to look at long-term permanent residency options. It does get so much easier if you're dealing with workers who you no longer have to worry about their work permits expiring, how we're going to get the next work permit. And sometimes for certain workers, we might not even be able to get the next work permit. So it really is of benefit to the employers who have that long-term thinking and saying, okay, we've hired this person. Now let's think about long-term. How are we going to be able to keep this person for the long term? I can't emphasize it enough. Right now, the level of rejections has gone through the roof, especially in certain visa posts like Abu Dhabi. And it's, they're using AI overseas and etc. But officers have also, the attitudes have also changed. The minister recently boasted a 60% rejection rates on temporary residence. And so you have to make sure that, applications are perfected, every factor is proven. This is why I highly recommend that you don't try to do this yourself. Right now, these are not applications that are easy to do. They're not applications that you can, just say, hey, why not? Shouldn't this person come through? No, every single T has to be crossed, every single I has to be dotted, everything has to be proven, every element has to be proven. And even if every element is proven, we still have cases that are just rejected for no good reason. Really, really no good reason. When we get the reasons back, they're ridiculous. We go to federal court and the Department of Justice settles with us. The federal court right now is inundated with cases such as this, and employers now, many times it depends on where they're applying to, where we have to apply to, but many times we are basically telling employers, be prepared that there's a very high chance of rejection at this visa post, and that you may have to go to federal court. And it may not take that long in federal court because these reasons may be very ridiculous and they will be settled and we can go back. But be prepared that, especially at certain visa posts, that applications can be denied very easily as well. All right. So we have a poll here before we get to questions. And we just wanted to see if you can sort of give us an idea so we can kind of tailor our questions and answers period. If you can say why you chose to attend today. Are you looking to hire international workers that are new? You don't have them yet? Or are you looking to help your current international workers? Or both? Or neither? You just wanted to have some information and join us today.
Wow, thank you, Elizabeth. I'm coming back over here, and we'll keep our eyes on the poll. I'll watch for the results. And while you guys are answering that question, we do have, which is great, we've got about 19 questions that have been asked. And I think I'll probably go through in chronological order. So I'll start with kind of the first question and work my way through. And I'm going to try and be careful to try not to have repeat questions. But you went over a lot, so thank you so much. So the first question on here is from Nick. And the question was, will the foreign applicant need to complete something on their end before moving forward? We have an employee who would like to have his brother come over and work with us. The company would like to sponsor his brother, and we're unsure of the next steps.
So definitely, Nick, come and speak with us. We'll have to see what the circumstances, what the job is, what the applicant is, and how we might be able to fit them under a category for a work permit.
Okay, so there's one answer there. Chris had a question early in the webinar, just when you mentioned wage. He was just curious how you calculate wage.
That's a very good question. So we're always looking at hourly wage. So if you give them an annual salary, you have to declare how many hours, regular hours are there per week, and then you do the division that way.
Okay, and then that's great. I have two that are sort of similar, one with a little bit of detail. So I'm gonna start with the first one. We applied for LMIA for an employee, but their work permit was denied and they were asked to leave Canada. The LMIA is still pending and has not been reviewed to date. If the employee goes back to their home country and the LMIA is then approved, what would happen? Question. Also, say in the meantime, it takes a very long time and we terminate their employment due to frustration of contract, would this impact their LMIA application that is still pending, or should we wait for a decision on the MLIA before doing anything with their employment status?
Sure. So likely the employee's work permit was denied because there was no LMIA in place when the officer got to the application. Now, normally, if they had applied for their work permit extension before their current work permit expires, they would have had implied status, which then ended when the work permit expired. So from that date of when their work permit was denied, they would have 90 days to file a restoration of status. So they don't necessarily have to leave Canada. They can stay in Canada, file their restoration of status, and hopefully in the 5 to 6 months before the officer gets to the restoration of status application, you would have received the LMIA and updated the application that way. Now, if it is that you received a refusal on, if it is that you actually don't want to hire them anymore, the LMIA is specific to the employer and it's your application. So if you no longer want to hire the applicant anymore, then you would withdraw your application. You shouldn't continue on with the LMIA because the LMIA is all predicated and you're declaring your intention to hire the worker once the LMIA is issued, and then you're going to apply for the work permit.
Okay, next one. We applied for LMIA in July of 2024 for low-wage permanent residency category, and it's still in process. We are informed that the department is still viewing the application received on March 9th, 2024. Our worker has been on implied status since September 2024 due to the expiry of their PG work permit. Now, the employee has received a refusal on their work permit, as was attached to the LMIA, which is still in process. Unfortunately, due to business needs, we have to move forward to hire the replacement. What options do we have now?
You simply, if you need to hire someone else, you need to hire someone else. And if that person, and unfortunately, we can look at other options for this person, but you know, that's unfortunate for that person. Yeah.
Okay. If I am going to apply for PGWP next month, do the new rules apply for me and my open work permit holder spouse?
Yes, it does. At that
Okay.
point, yes, it does. Yeah.
Okay, awesome, easy. Question about fields of study in the fields of study category. Do you know what the fields are for the field of study category?
Yes, it's on the IRCC website. What I'll do is I'll include that link. I think I didn't include the link onto the slides, but I'll include the link on the slides. And when you guys receive them, then you can click on that.
Okay. This one, can you please explain again about PGWP and if there is time, which I'm guessing time frame for that?
Okay, so postgrad work permits, they're work permits that students, international students, they are entitled to after they graduate from specific programs in Canada. It used to be you graduate from any program, from a public college or university, and you were eligible for the postgrad work permit. So 2-year program, you get a 3-year work permit, 1-year program, you get a 1-year work permit. That has been changed now for non-degree programs. So for bachelor's, master's, PhDs, that still applies. But for college programs, or even sometimes universities themselves offer non-degree programs, that's no longer the case. For non-degree programs, now it depends on the field of study of their program. If your program is not in one of the select fields of study and it's a non-degree program, you no longer are eligible for a postgrad work permit when you graduate, if you applied for the study permit after November 1st of last year. If you applied for it before November 1st, so people who are graduating now should be fine because they applied for their study permit before. But people who are graduating maybe next year or later this year or the year after, depends on when they applied for their study permit, they may not be eligible anymore for the postgrad work permit.
I have another one here from Nick. We have an employee whose brother is in the Philippines and would like to come and work for us in the construction industry. What are the steps to have this applicant come to Canada? Does the employer need to create a profile under LMIA? Does the applicant need to create a profile first? Can you kind of walk through some of the steps or where to look into getting this done? Thank you.
We come and have a chat with me and I'll walk you through the steps for sure.
Perfect. Then someone else asked, so implied status, what does implied status mean?
So implied status is when you currently have temporary status in Canada. If you have a work permit, a study permit, or visitor status, and you apply to extend your status before your current status ends. Let's say I have a work permit and it finishes in February 1st. It ends in February 1st. If I apply to extend that work permit on January 31st, the website says you should do it 30 days before. That's a recommendation, not the law. The law is as long as you apply before it expires. So let's say I apply January 31st and I don't have a decision made until March 1st, for example. Oh, no, it's not going to be made by March 1st. I don't have a decision made until June 30th. Okay. Now, my work permit expired, right, on February 1st. What's my status from February 1st to June 30th? You have implied status. That means I have the legal right to continue to work in Canada until a decision is made. Now, I do have a pet peeve, another pet peeve. I have many pet peeves with immigration, but I do have a pet peeve. One of my biggest pet peeves with IRCC is this WXEXT letter, work permit extension letter, that they had all the best intentions of doing when they started creating these letters. But my pet peeve with it is it's very, very misleading. So on these work permit extension letters, they say, you have status until such and such date. And, or when a decision is made, whichever comes earlier. This date that they put on there is a random date. Sometimes they say 6 months. Sometimes they say it's 4 months. It is meaningless. Okay. If a decision is not made by that date, does the person still have status? Yes, they do. What this letter, however, really seems to show is that basically this person says if they don't have a decision by that date, their status ends. Their status does not end. It's merely there to try to help ease your worries as an employer, which it might ease for a little bit, and then later on it's just like very frustrating because you might, most employers think, oh, that means that their status has ended by that date. The other thing is that also the status, also it helps with their OHIP as well, to extend their OHIP as well. Sorry, that's a long meandering answer to this question, but that's essentially implied status there.
Okay, perfect. And the next one actually is about implied status as well. And they're just asking, how would an employer prove that he didn't know someone left the country while on implied status and then returned?
Good question, but many times the officer at the border would let them know as well that they aren't allowed to come in, or even if they're allowed to come in, that they have they're no longer allowed to work.
Okay. Can an employee continue working while on a bridging permit?
Yes, they can. If they're on a bridging work permit, they are able to work. That's an open work permit.
Okay, perfect. Who can we contact to verify scope of NOCs?
Who can we contact to verify scope of NOCs? NOCs are occupation codes that are on the website. There's no verification of the scope per se. It's interpretation of whatever the government has stated. Essentially, basically come to us and we'll help determine what the occupation code is for your worker.
Okay, awesome. Have one about extension. So if a work permit extension application submitted within Canada has been pending for more than 5 months without a decision, what steps can someone take to expedite the process and obtain a decision?
Not a lot. There's 5 months is nothing. 5 months is very, very normal processing time for a work permit. You could see if a member of parliament's office might be able to help. If it's, over a year's delay, we can look at going to the federal court for a mandamus. Sometimes we file these web forms to see what's happening, but most of the times the web forms don't do a lot in trying to get any movement on a file per se. But honestly, 5 months for inside Canada, that's normal processing time.
So sadly, patience.
Patience, yes, that's right. Yeah.
Okay.
Sometimes we can get notes to see if there's something specifically at issue with a file. We can do an ATIP. But yeah, right now they're also talking about cutting 3,300, 3,300, 3,500 positions in IRCC as well. That's the announcement. So expect processing times to go even longer.
Wow. Okay.
Yeah.
All right, I have one from Dana. We are a tech company where all the employees work from home across Canada. No physical office, but we're registered as a company in Alberta. There's a program in British Columbia for tech companies called BC This program states that the physical office must be in BC. Can an employee apply for this program if they work from their home in BC, but the company is registered in Alberta? And then she said, please note, we pay all our taxes and fees to the BC government for BC employees.
So do come and speak with us. You do have to have an office in BC. Now the BC office could be something where it's a virtual shared office space or something where they can report to, but you have to have some sort of presence in BC as well. So do come in and we can look at some options.
Okay, next one. If we have an employee who is currently on their open work permit and not working with us, if their work permit expires end of this year and they've not received PR through express entry by then, can we still extend their work permit or will they have to leave the country?
Well, the question is, can you extend their work permit? And the answer is, well, we have to see if they fit under another category. And how they might be able to fit for one of these work permits.
Okay, sorry, I joined the webinar late. Not sure if this was discussed earlier. If our employees applied already for PR yet and have not received the decision and their work permits are expiring and are under OWP, bracket PGWP or non-LMIA, can they apply for an extension of their work permit?
So it really depends on whether or not they actually applied. A lot of times people think they have applied just because they put themselves into the pool. If they just put their name into, for example, an express entry pool, and they have not actually been invited to apply, that does not equal applying. If they have been invited to apply and they have submitted their application, then likely they would be eligible for a bridging work permit and we can apply then. If not, then they'll have to qualify for a work permit under another category.
Okay, great. This one's interesting. So we have an employee in a skilled position, laboratory technician, in a small business that's worked for 2 years with specific training. She's in Canada. She is in Canada, as is her husband, on an education permit. What are options when his education permit expires?
So we'll have to take a look to see whether or not the husband can get a job, or if your employee could get their own work permit, or maybe they can apply for permanent residence as well. So there are some options now, but let's take a look at those options now before the husband graduates.
Okay. Sorry, the next question's a bit like open-ended, and I'm just curious because you may be able to reflect back on during what your webinar where you're speaking about this, but it's just, what about hiring independent contract remote workers? So
yeah, it really depends on which way we're going to do this. Some free trade agreements, they actually require the professionals to be independent contract workers, but other applications such as the LMIAs and they require them to be employees. So we do want to take a look at what they qualify for and what the structure is and how we might be able to do this.
can I ask a follow-up question that might interest some people? I just know that in general, not when it's specific to like foreign workers and immigrant workers, but in general, misclassification of employees and independent contractors is a big thing. It's one of the most common things that we deal with. And so I'm just wondering, is that also, something that happens often when we're talking about immigrant workers as well?
Yes, absolutely. The relationship and how that works, it's central to the kind of work permits that is required, and also for permanent residents as well.
Okay. So be careful when we're talking about employees versus contractors. All right, we've got about 3 minutes left, so I'm going to try and get through a few more questions here.
Should we look at the poll at all, or did
Oh yeah, let's do that. Hang
people?
on, let me ask. I'll ask one more
Oh,
question, and we'll zip over to the
okay,
poll. So,
sounds good.
last question: is it employers' responsibility to fill out applications for permanent residency, and write a letter?
Well, this is a great question to end on, because you know, whether or not you support your worker, that has a lot to do with, it's a cross between employment obligations and employment law and immigration law. So in immigration law, a lot of times a worker needs the employer to help them with certain kinds of applications. For example, provincial nominee programs like the Ontario Immigrant Nominee Program, OIMP, they might require the employer to fill out a form called the employer form. Otherwise, the person wouldn't be able to apply for their permanent residence. On the other hand, the employer form does require a lot of information that is private to the employer that they wouldn't want the employee to see. Sometimes if they hire a, as lawyers like us, we can act as the firewall so that we file the application and the employee doesn't see the employer information. Oftentimes the employers say, well, do I need to do this? Do I have to do this? And that's more of an employment law question that I would ask some of my employment colleagues to look at. The case law has, I think, been moving towards more and more expectations for employers to support their workers. That being said, as to how much an employer is required to do so, I think that's still up in the air. Overall, though, if you do want to hire international workers, you do want them to stay with you, it is very, very important to look at all of these immigration laws and permanent residence changes, because they're not like Canadian workers. They might be very hardworking, and they you might want to keep them, but they do have certain needs that go beyond what Canadian workers need. And you have to be very attuned to this, and you have to be prepared that if you do want them to stay with you, that there are certain things that your company may need to do, especially in the current climate where we have 2.3 million international workers and international students in Canada, and only around 100,000 to 200,000 spots for permanent residents. The competition is crazy fierce, and a lot of employees will need employers to help them get that edge to stay in Canada.
Okay, great. Wow. Just before I go to the poll, just to let everyone know who's asked some questions that we weren't able to get to, you are all going to receive a recording of today's webinar via email. Feel free to respond to that recording with any questions you might have, and we'll do our best to triage those questions, just so you know, we don't want anybody to feel left out. When it comes to the poll, so I have the results here. It was 38% of people answered, we are looking to extend current international workers. 27% were both looking to extend and hire. And then neither was 28%. And then last but not least, at 8% was they're looking to hire. So the majority of people were either looking to extend current international workers, or both hiring and extending. And then there was actually a good chunk of people who was neither. They're just here for, I think, more just for general information.
Wow, that's super interesting to know. That's super interesting to know. Well, I'm glad that first of all, the neither. I thought nobody would be here who might be interested in the boring old topic of immigration law, but that's fantastic that you guys are here. Thank you for attending. And for those who are looking to help their current workers here, it's tough times, but we can usually still find some options for you. So happy to have that chat with you guys about how that might happen. And for those of you who are still brave enough to want to hire new workers, again, there are still many, many options out there. And we'd be happy to have a call with you about that.
Awesome. So I guess in clothing, thank you so much, Elizabeth, for spending the time with us. Also to I think there was 104 attendees, and most of them stayed right to the very end. There's lots of additional questions and lots of interest. So I definitely think that Elizabeth will be back in the future. So yeah, thank you so much for being here.
Well, thank you so much, everyone. Thank you. Take care. Okay.
Okay, have a great
Bye-bye.
day, everybody.